Good evening and welcome to another episode of Maintenance Matters. Felicity, welcome again. We're talking to Felicity An Guest, a financial abuse specialist. How are you doing tonight?
Absolutely fantastic. Thank you very much. How are you?
I'm always good, like always, like always. Now, Felicity, we're coming to the end of this discussions on financial abuse. Surely there will be more discussions in further webinars and stuff like that. But bringing it back to the maintenance side of things, what is your feeling regarding the financial impact that it has on the postponements in maintenance courts taking forever? What is your general feel about that?
I want to make it clear about, it's about intent. And that's where, where abuse is, it's intentionally abusive. So, for example, if the applicant knows that the defendant has the means to fulfill their legal obligation and they don't, and then they use all these various tactics just to string it out, because often we hear victims saying that they threatened me and they said that if you go to court, you are going to regret this. So that is the abusive behavior. You are going to regret this. So what is it? You know that something is going to happen because you've heard those words before. It presents itself differently. So post-relationship, where there's not close proximity, money is the most powerful tool to punish you. So because you dare to lodge an arrears complaint, now I'm going to employ a legal representative, and the first time, sorry, I want a postponement. The next time, either the legal representative couldn't make it or the applicant was sick. The next time, the maintenance officer's sick. A whole plethora of excuses, and then you can start again at A. So often we see postponements like going on for periods longer than 9 months and sometimes a whole lot longer, because we also know that part of it is getting financial documents. So a glimpse into that is they hide the assets, or they put them into the money is channeled through somebody else, or they use cash.
But due to the postponements, they actually have time, and they can put effort into hiding their assets.
Mm-hmm. Well, yes. So it's again, kind of speaks to the intent of it. It's the deliberate intent to prevent, because it's inevitable. You are going to have to pay the arrears if you have the means or you have the assets. And why it's important to create the awareness, even if there is no legislation, it's if we don't and there's a postponement, then for the person that's sitting there, it's just, postponement, without considering the impacts. And the impacts start becoming dire the longer it happens. That the applicant says, because this is now 12 months down the line, I have accumulated debt through a loan shark where I'm paying more interest, for example. And what he's spending on legal representation is like a year's worth of my maintenance.
No, that's completely understandable. There's a provision in the Maintenance Act in Section 10.6 where the Act specifically says that maintenance matters needs to be concluded as speedily as possible. And this Section 10 clearly states that it needs to be concluded in number and in duration. So there's a limit to time that they have to complete that, and the courts don't usually enforce that. They just grant the postponements, and it's just taking forever and just being postponed at the request of the attorneys, or it might be the maintenance officer being ill, like you just mentioned. And the people out there, the lay people, the complainants, do not know about Section 10.6 that specifically says that it should be limited in number and duration. Linked with that, also in terms of Section 10.6b, there's a direct provision that if a postponement is necessary, only if a postponement is necessary, that you could request the maintenance officer to make an interim order. With other words, it is an order that is not a final order yet, but pending the finalization of the maintenance matter, an interim order could be made for that mother to get some form of compensation, some monetary compensation in the form of maintenance, in order to feed her children, or whatever the case might be.
I mean, I hear it often where that's a new application. So we're and even in that situation, when interim order has been made, they often say, well, he hasn't complied with the interim order, so can I go and report it because, our final hearings in 3 months' time? Is it worth me reporting that he's not complying with the interim order? And just based on what I observe, is no, because if you go and report that they're not complying with an interim order, the likelihood of you getting a court date before your next court appearance is unlikely. So, again, like one of my concerns is if the people that are meant to protect the most vulnerable, which is children and women, if they're not aware of this. So, I mean, the legislation for me needs to be more punitive or swift in terms of preventing this, because I think the defendants know that they've got 3 months. They know the grace period, and that's how it's manipulated. But if the person who's processing that or receiving the complaint realizes and understands that there's a possibility that this family is not going to eat for the next 2 months, or it's going to be very difficult, I believe that they will act differently.
No, I completely understand. I think that the complainants out there listening to this should also become aware, read up on the Act, and look at specifically Section 10.6, where it states that it should be limited, the postponement should be limited, and that you can take the maintenance officer to task and tell them, listen, but this is what the law says. I am being prejudiced. I am being financially abused to a certain extent because the person is not paying. I think it should be important that you familiarize yourself and become educated in the law before you come, not in the law, but in certain specific sections of the law, in order to make your maintenance application process as smooth as possible. Just with regards to the interim order and the people not paying, remember now that an interim court order is a valid court order, and it is exactly the same as if it would have been a normal order granted by court. So if a person is in default with an interim order, that could result in criminal charges being brought against him. And the only defense that person could have, the respondent could have, is by he does not have the financial means to pay that. And that would be a valid defense. But up until that stage, he could be held criminally liable for not observing and doing the interim order.
Sure, you say that, and we'll probably have to have a whole section just on that, because I mean, I think it's common knowledge that they don't want to criminalize defaulters, because what is criminalize? It's a criminal offense. Do they get arrested? Do they go to jail? Are they fearful of those consequences? So I think that's maybe one that we should have, like, the next time we speak, that aspect of it.
I think that's a good idea, and that's definitely then a topic for our next webinar. Felicity, thanks so much for your time, and keep well.
And you too.
Thank you.
Bye, Eugene. Bye.